Good afternoon again, everyone. Very glad you all could join us for what is the 5th webinar in our ConMAS-EL's monthly webinar series. We actually had this webinar scheduled for a different time, but we moved it up in light of OSHA's issuance of the final rule to the revised hazard communication standard. We want to get as much information out to as many of you as quickly as possible now that the standard has been finalized. OSHA finalized their standard on May 20th, and the effective date is July 19th of this year. As we'll talk about in the webinar a little later, the compliance deadlines are actually set out a year and a half. So there's no immediate action that needs to be taken related to the revisions that have been made. But we would like to let you all know what those are so you can start planning, preparing for any changes you might need to make, either as a chemical manufacturer or an importer, distributor, or a downstream employer. I don't know because I don't see you, so I don't know how many of you out there are downstream employers versus chemical manufacturers, but we're going to try to at least give a broad overview of all of the major significant changes in this rule for both the manufacturers as well as downstream employers. I am very, very excited today to be part of this webinar. As you all know, probably I've done a tremendous amount of work on the chemical rulemaking space over the years. However, I'm not excited about that. What I'm excited about is that Maureen Ruskin is our special guest today. Maureen, as many of you probably know, who've dealt with OSHA over the years, has been with the agent, has recently retired from the agency, but was with OSHA for over 25 years, writing and developing regulations and providing supporting analysis, especially in the chemical rulemaking area, HazCom and GHS in particular. Maureen is one of, if not the primary architect for the hazard communication revision in 2012, which aligned for the first time HazCom with GHS. And I know has spent many, many hours, hundreds, thousands, I don't know, Maureen, working and focusing on harmonizing the chemical our HazCom standard with GHS, and which was done in 2012. And was I don't know if I can say primary author, but certainly one of the primary authors and the lead on HazCom and GHS while the agency was preparing the proposal for what is now the final rule. Maureen had retired by the time the final rule was issued, but she has just a wealth of information. So we're very excited to have Maureen join us, and she is going to be very prominently featured in this webinar. In fact, I'm going to have Maureen, after I kind of go through our agenda, I'm going to have Maureen take it from here. And Maureen's going to go through, first give a sort of an overview, just a few minutes on a background to the HazCom standard itself, not this new rule, but just sort of the backdrop for the new rule, and how the HazCom standard has been aligned with the global harmonization system that applies in most of the rest of the world. And then we're going to spend the bulk of the time summarizing the changes that have been made to the HazCom standard under this new rule, and transition issues, meaning, all right, you guys out there, you've got to now comply with the new rule. What are the rules of the road, essentially? What do you need to know, both, again, for manufacturers as well as for downstream employers? And then Maureen will spend a couple of minutes on next steps at OSHA, other documents that are going to be issued by OSHA that will help the regulated community in understanding how to comply with the regulation. My role is predominantly here going to be to emphasize certain points that I think are important for those of us that have to understand how to comply with the rule every day once the compliance deadlines hit. Maybe asking Maureen to provide some clarity on certain topics as we kind of run through these. And as I said at the outset, we are going to try to save plenty of time towards the tail end, at least 15 minutes, hopefully, to allow you all to ask questions. as we always do in these webinars, if we can't answer the questions on the spot or we run out of time to talk to y'all, we will send, just shoot us a chat or follow up with an email, and we will get back to you via email. So with that, let me turn it over to Maureen. Thank you very much, Maureen. We're so pleased to have you partnering with us on this webinar and also going forward in answering thorny compliance questions for the regulated, our clients and the regulated community in general.
Thanks, Kate. This is one of my favorite subjects to talk about, so I am looking forward to the next hour or so. So, as Kate said, we'll start with an overview of HazCom. This is just to make sure that we are all on the same page and really what HazCom was designed to do. The HazCom was designed to make sure that the information flowed down to the employee who is handling and is exposed to the hazardous chemicals. And this starts with the chemical manufacturers, as OSHA has pointed out, should have the most robust knowledge of what the hazards are of the chemicals that they are producing. They then transmit this information down to the employers through the use of the labeling on the immediate container as well on the safety data sheets. The employer then has the obligation, and this may sound funny, to receive this information, and OSHA does talk about how this information is received, and that they then must create a written hazard communication program, which includes a list of chemicals, and they have to make sure that this information is all available to their employee through maintaining the label on the containers, maintaining ready access to the safety data sheet, as well as training the workers on the hazards that they are exposed to, as well as the program and how to access all of this information. So that is the basic premise of hazard communication.
And if I could, Maureen, just point out, when I think about HazCom, I think SDS, labeling, training, written program for downstream employers. Obviously,
Correct.
For chemical manufacturers, you've got the hazard classification and characterization, and Maureen's going to talk all about that. But in a nutshell, sort of the cheat sheet in my mind is those are the four main components of HazCom in a nutshell. Now, once you open the shell, there's a lot in each of those, but that's sort of a nice, summary, if you would.
Correct.
At least that's the way I think.
And then moving on to GHS, which is the Globally Harmonized System of Classification and Labeling of Chemicals, which is a mouthful, so everyone just says GHS. And this is a system that is standardized and harmonized for the classification of chemicals and then the dissemination of the information, both on the labels and the minimal information on the safety data sheet. And this was to cover all hazards as well as all of the different sectors, not just the workplace, but environment, consumer products, and even transportation. So it was really designed to cover a lot of ground, and that in itself had made it quite a difficult task to do that. So, as I said, it covers all hazards. It covers physical hazards, health hazards, and environmental hazards. Now, when GHS was developed, there were many countries that had robust chemical regulations. The US, Canada, EU, Australia, and all of these countries got together. It was tripartite with regulators, worker representation, as well as industry, got together and developed this system. Now, there were several premises that went on in developing this system that no one would reduce their protections because of GHS. And in doing so, and since it's covering many different sectors, GHS created this building block approach so that competent authorities who are implementing GHS can choose from the various options in the GHS to fit their regulation. And this comes into play when you are looking at the workplace versus consumer, that you may have more sensitive populations that are exposed to consumer products. So there were options that that competent authorities could take when they were adopting or aligning with the GHS. So this, a very important point, is that it is not a model regulation. If anybody is aware of the transport of dangerous goods that covers just transportation, that is a model regulation. And when DOT implements that, they are basically taking it wholesale with some, of course, notice and comment that they may make some adjustments, but it is written to be put in wholesale into regulations. So it is just a series of criteria and clarification, text, and guidance.
For criteria.
Excuse me. So this is what was very important when OSHA was first implementing the GHS. So in bringing in the GHS, particularly in this update, since we aligned back in 2012, this update maintains the alignment with the GHS. This is primarily revision 7. It will address some issues that were identified in the implementation of HazCom 2012, or aligning with the GHS. Since it was a very different system, there were some issues that came up that OSHA needed to deal with and address.
One of the issues and concerns I've always had with the way OSHA, with the way the process works, is OSHA spent, for this rule, actually, in the way rulemakings go at OSHA, this was fairly quick. The proposal came out in 2021, 2024. 3 years later, we got a final rule. Now, we all know that OSHA had been working on this for years and years, even prior to issuance of the proposal. But the problem is, the goal of this is to align with GHS. And we have some clients who I'm sure on the phone who have international operations. So they've got operations in the EU and Asia and other areas. This aligned with this particular revision has aligned HazCom with Rev 7 of GHS. And we know now that GHS is far beyond Rev 7. I know the rulemaking process pretty well, and I don't see any way to fix the problem, but it seems like we're always going to be behind where the rest of the international community is, because we can't revise our regulations as quickly as GHS revises itself. Any comments on that point?
Yeah, so I'm actually asked about that. Why revision 7? How does OSHA stay on top of this? Several answers to that. One, at the time, as you know, rulemaking takes a long time. So OSHA was strategic in choosing a revision that had significant changes that we thought would help and enhance the protection for the workers. Also, at that same time, many of our trading partners were also going to revision 7. OSHA also does, in certain aspects, looks forward and says under certain circumstances you can use more up-to-date revisions, and in particular that has to do with the precautionary statements. Also, OSHA allows for supplemental information. So if there is a new hazard category or class, that can be added if the manufacturer so chooses, as long as it does not contradict the required information. And finally, some of the changes that are going forward are clarifications. that OSHA might be able to say that this is a clarification and that you may follow this updated guidance because you will come out with the same classification or the same endpoint as that you would under the criteria that is in the regulation. So there are many things that OSHA can do in between the rulemakings to keep up with the GHS. We also work very closely with Canada, our biggest trading partner, to ensure that as best possible that we are aligned. Now, one of the things that I tell people that you will not see the exact same words between the Canadian regulation under WMIS and OSHA's regulation under HazCom, and there are many reasons for that. One is that the Canadian regulation does not cover the workplace. The provinces cover the workplace. Well, HazCom does. So you bring in different things into HazCom. The other thing is that Canada regulation is a criminal statute, while OSHA's is a civil one. So your citations are very, very different. So what I tell people is that if you took these two regulations and you put them up to the light, you would not see any light. However, we work very closely with Canada to make sure that you can have a common label and a common safety data sheet. And some of the final rule sort of takes that into effect, some things that US and OSHA have worked on together, or OSHA has taken some things from the Canadian regulation that were helpful. So this is all in trying to ease compliance between the two countries without losing any protections. And then finally, we work very closely with our sister agencies. And here we, in this final rule, help to improve the alignment between OSHA's sister agencies, such as Department of Transportation and the EPA.
And we're going to talk a little bit about DOT labeling as compared to HazCom labeling and the effort that OSHA has made in this rule to align those two things in a little bit. Yes. So, all right.
So really very quickly, as I said, we talked about what HazCom is. Basically, in this rulemaking, OSHA kept the same basic framework. Chemical manufacturers create the information, send it down to the employers, and the employers train their employees. And similar to the regulation back in 2012, OSHA has maintained or enhanced the overall current level of protection of HazCom.
And I think the folks on the phone are going to want to understand, and we'll talk about this towards the end, I think, you know, there's probably some skeptics out there that when we say it has either maintained or enhanced the level of protection, what that means for the employer and their obligations. Does that mean that now, at least when the compliance dates come to pass, there's going to be a much more stringent requirement or requirements that have to be met? And, you know, obviously this is all brand new and we're looking at it carefully, but Maureen, it's my sense that while there are some things that are different, I don't see a heavy lift here in terms of compliance obligations compared to the existing standard. Is that your view as well?
Correct. Correct. The overall requirements are basically the same. However, there are some shifts in classifications. There are some improvements in the precautionary statements and how they are used. And OSHA has put in some additional flexibilities. So I'll be going through those as I work through the updates. But yes, it really isn't a wholesale change compared to what we did in 2012. Even though we maintained the framework, it was a major change. Yeah, downstream users will probably not notice a huge change, maybe some shifts in some labeling.
Yeah, and I think so for you, the regulated community out there, our clients, and those of you joining us today, the trick to my mind on this, the compliance issue to focus on are these minor shifts that actually sometimes make it easier, but they are to comply, but they are different. And I think the gotchas are going to be if you don't know exactly what those differences are, and when compliance dates come and go, you need to make sure that you've changed things. Doesn't mean the new thing is harder, but if you're still doing it the old way, that could be the problem. So we want you to understand the nuances of the changes and the shifts.
So, as I said earlier, the primary purpose of this rulemaking was to maintain alignment with the GHS. And this, we say, is primarily with Revision 7. This is because, as Kate has pointed out, there were additional revisions when OSHA went out and proposed. It takes many years for OSHA to develop a proposal, let alone a final rule. And in so, it asked several questions about some things that had already been published in Revision 8. So when the final rule came, based on the comments that OSHA received, both on the rule as well as its questions, it took some of the updates from Revision 8. So OSHA was being forward-thinking there. So basically, I'm going to not try to get too technical here, but there are updates to Appendix A, which is a classification for health hazards, where GHS and OSHA revised the health hazards definitions. This was just to make them uniform and to take out any references to actual testing. It updated the skin and corrosion and irritation chapter to Rev 8, and this is really basically to better incorporate non-animal testing. Though OSHA did indicate that existing chemicals should not need to be retested or reevaluated, that this is all based on the current data. But going forward, you have more options and a different, slightly different scheme based on the non-animal testing. As well as there were some updates to the serious eye damage and eye irritation chapter, where OSHA gives a better understanding on how to use pH, as well as some non-animal tests. And then there were just some.
Maureen, yeah, I'm so sorry to interrupt, but let me level set for the audience out there, because we have a whole bunch of people on. What Maureen is talking about, these changes are applicable to the chemical manufacturers who are doing a hazard classification or hazard characterization in some instances, these changes. For you downstream employers out there, this is not, don't worry, this isn't what you have to be worried about or think about. This is who's creating your label and your SDSs, how those analyses are done to make the determinations about what go on those. So this is for the chemical manufacturers.
This is, Appendix A and Appendix B are mainly chemical manufacturers. However, what you may see is a change in what you have on your label and your safety data sheet downstream. In Appendix B, for physical hazards, again, manufacturers have some additional hazard classes and hazard categories. Here, OSHA picked up the additional hazard categories under flammable gases. This is to improve or better discern what the actual hazards are. It introduced a new hazard class, desensitized explosives. These are explosives that have been treated so that they don't contain their explosive properties, but if they sit around too long and they may become explosive. So there are improved communication on what to do. And then in the aerosols chapter here, OSHA has differentiated better between aerosol can and a compressed gas, that they are now totally separate, so you can have better communication between the two, as well as added a new class called chemicals under pressure, which is not quite an aerosol and not quite a gas under pressure, and it sort of fell in between. So you have a new hazard category to better disseminate what the hazards are. Then OSHA updated Appendix C and Appendix D. Again, this is primarily the manufacturers that will have to deal with this, but this is what downstream users will see. And I'm going to go into a little bit more detail on these changes because this is what downstream users will see. So first of all, in the allocation of label elements, which is in Appendix C of this standard, you'll see that OSHA has brought in new hazard statements, precautionary statements for the new hazard classes and categories, and that will be presented in Appendix A and Appendix B. It has given better instructions on how to combine statements, particularly the medical response statements, which could be triggered by many different hazard classes. It gives better instructions so that the downstream users will have a better idea of what, not only what to do, but when to do it. So, you will see those changes. And then it updated some precautionary statements. I'm going to get a little bit in the weeds here. I hope you don't mind. But when GHS was developed, the precautionary statements were what they called codified, but they weren't harmonized. And so now the subcommittee has been going through, have been improving these statements, have been improving the conditions on when the manufacturer should apply these statements, so that when you get the label, you are getting the information that you need and not just a laundry list of random statements. So that's the idea of these changes, so that the information on the label and the safety data sheet is comprehensive but meaningful. OSHA has also added some additional flexibilities, and some of this has to do with the chemical supply. So when OSHA finalized the rule in 2012, it lifted a long-standing stay on updating the label. And it has told the manufacturers that you must update your label when you have new significant information on the hazards. Well, there are certain types of industries where there is a very long chemical cycle, supply cycle, and that there could be additional hazards if these companies need to go in and maybe either relabel, which could have ergonomic issues, or need to repackage, which would then expose their employees to potential for chemical exposures. So OSHA recognizes this, and to address this in this rulemaking, it allows a flexibility that if a container has been previously labeled and has been released for shipment, the chemical manufacturer, though they must update their label in 6 months, they do not have to attach it to that immediate container, and they can send the new label along with the shipment. Now, for downstream users, this is really just an explanation on why, in certain times, that you may see an additional label in your shipment that you received. So this will be.
I'm sorry, Maureen, just to clarify, because this is important for our chemical manufacturers. The new rule, while you still have the obligation to, within 6 months of knowing of a new hazard or classification or impact on your characterization or classification, you do have to update the label. But if you have the old existing label on containers already, that have been released for shipment. And we'll talk about what released for shipment means. Maureen will explain that. And some of you probably are very familiar with it in the EPA context. If those labels are on there, then you do not have to change that label. You leave it on the container. However, you do have the obligation to make the new label within 6 months of gaining that information, that new information that affects the statements on the label, and sending that new label along with your shipments that are going out that have the existing label on it. That states the obligation of the new rule correctly, right?
Correct.
Okay.
Some additional flexibilities that OSHA has put into the rule was, again, going from the original hazard communication standard, which only indicated that chemical manufacturers had to put appropriate warnings on their label, to the more prescriptive label under GHS. There were some issues that arose, and this was worldwide, on what to do with small containers. That often these containers are such that the information would be so small that you wouldn't be able to read it without, a magnifying glass, so to speak. So OSHA put out some letters of interpretation on how to deal with this when it was infeasible to put all the information on. And in this rulemaking, in this final rule, OSHA has just sort of codified this so that everybody is following the same rules. So if you have a small package, and OSHA has defined this as 100 milliliters or less, and you cannot put all the information on the label, and this means not only attached directly to the container, but with tags or a fold-out label, you can put a reduced amount of information on the immediate label as long as the full label is on the outer package. And OSHA has defined that as the minimal information of the hazard warning and the pictogram and the signal word, and then the full information would be on the outer package. Now, OSHA has further gone down and said, okay, sometimes there are very small packages, and OSHA defined this as 3 milliliters or less. And that no label elements are required if putting a label on that very small package impedes or interferes with the normal use of that container. And this is often in a laboratory where you are taking one of these very small vials and putting it into a piece of equipment, and that having any sort of label there would make that unusable. This is modeled after the Canadian regulation. So here we are aligned with Canada as well. OSHA made some significant updates to the safety data sheet, and this is one that many of you have probably heard about. And here OSHA has made a clarification in section 2 of the safety data sheet. And here, again, this has to do with the changing from appropriate label to the prescribed label. There was an issue where people were saying, what do I actually put on the label? I have a product that is designed to work with another product, and there are additional hazards when these two products are put together. OSHA had given some guidance on what to do there, that the primary containers of the original products must have the hazard warnings of those products, and then on the safety data sheet, you put in the hazards of what an employee will be exposed to under normal conditions of use. OSHA has codified this in the various ways of updating the paragraph on classification. You have 2 separate types of classification of the chemical's physical form, meaning how it is shipped or what it can be transformed into under normal conditions of use. And then you have the conditions of under applications and use if there's a chemical reaction and it creates a new chemical hazard that goes solely on the safety data sheet. So under the physical forms go on the label and the safety data sheet. Chemical reactions due to known or reasonably anticipated use goes solely on the safety data sheet.
And Maureen, this is an issue that was very, very controversial in the rulemaking. There was great concern among the chemical manufacturer regulated industry, if you will, that OSHA was expecting something that was impossible to do, which would be for the chemical manufacturer to anticipate and understand every theoretical conceivable use that could possibly be put to a chemical once it's sold by the chemical manufacturer to its downstream customers. And there that created a lot of back and forth with the agency. The agency, you know, regardless of whether there was the concern was merited or not, you may have had a different view. You were at the agency at the time. But this rule has adjusted the language from the proposed rule. Your final rule,
very much,
OSHA's final
very
rule.
much so. It has it has changed the wording to make sure that it is clear. It clarified it that it is only under certain aspects, of application and use of the downstream users for D1II, and it also discussed in the preamble, and I know many people don't read the preamble, but it discussed in the preamble at quite great length that one, it is not changing the obligation of a manufacturer, that if a downstream user is a manufacturer, they are now taking responsibility. Two, it described when and how or what is considered known or reasonably anticipated, mainly telling you that no, OSHA does not expect people to know how a chemical is used if it is a commodity chemical or a bulk chemical that might have thousands of uses. It is also explained that it's not expecting the manufacturer to go and do a survey, unlike in the EU, that you have to know all the uses of your chemical downstream, but reasonably known or reasonably anticipated. So this is not a new concept in HazCom, but is one that is now more explicit in the rulemaking.
Clarified, made more express and explicit, better defined in the preamble. And I think chemical manufacturers, based on the language in the preamble that I've reviewed, I think chemical manufacturers can feel assured that what they need to concern themselves with are uses of their chemical that they would expect and intend, why they make this chemical and why they put it in the marketplace, the purpose to which it is intended to be made and can reasonably anticipated would be made. But if there's an errant downstream manufacturer who is using your chemical in ways that you as the manufacturer would not reasonably have expected, that is not an obligation for the manufacturer to determine, figure out, and label, and do the hazard classification based on.
Correct. Just some quick additional changes in the safety data sheet that you may see. OSHA is allowing manufacturers to use concentration ranges under trade secrets, but if they do so, they must use prescribed concentration ranges. This is another thing that we have aligned with Canada. This is a long-standing Canadian their regulation, so that now we are aligned in that as well. Just some other changes in Section 8 is just some clarification between Section 3 and Section 8 and when you need to add PELs and TLVs or other exposure limits in Section 8. Section 9, which is the physical chemical properties, this is really just an update and realigning of what is expected on the safety data sheet. I think the big thing that's included here that you may see is that you will see your possibly a particle size, which is really just so that you might have an indication whether you have potential combustible dust or a nano material. And some updates to Section 11, just so people understand the data that you're using in your toxicological information. Real quick, in coordination with our federal partners, here OSHA has had a long-standing facility on when chemicals are shipped, what OSHA calls a bulk shipment. And this is where the immediate container is the actual mode of transportation. And this is, you know, a tanker truck, a rail car, intermodal containers, that they have allowed the manufacturer to have the label either on the container, but you may not be able to do that because of the transport, or with the shipping papers. What OSHA has added here is that they will allow it by electronic means as well, as long as the downstreamer opts in and can receive it. The important part is that this label is received by the people who need it when the material is delivered to the downstream user. The other thing, this is sort of a minor thing, but DOT updated their regulation to allow an OSHA pictogram on a shipped container. OSHA has just modified their rule to align with the DOT rules. And really, as we indicated before, this new term, release for shipment, which means when it is packaged for, labeled and packaged for the shipment, is modeled after EPA's definition. So if you are, if you deal with pesticides, this is a very similar definition and will be triggered in a very similar way.
And Maureen, on that issue of release for shipment, I'm reading the rule to mean that the container, let's call it a barrel, the container has the label affixed, the container is closed, the product is in the container, but it could be sitting in your warehouse and, you know, being readied for shipment, meaning being palletized, or, you know, put in some other larger container. That activity doesn't have to happen, but the individual package has been closed, labeled, filled, and is essentially ready. If someone wanted to come and pick it up, it would be ready to go.
It would be ready to go. Yes,
okay.
Correct.
Okay, all right.
That is my understanding.
Mine too.
So as I mentioned this throughout, that there's coordination with Canada. One of the extra things is Canada has something equivalent to OSHA's hazards not otherwise classified, but they require to have a pictogram. So OSHA has put in their final rule that if you have an HNOC, you may use the exclamation mark as a pictogram there to, and Canada will accept that so that you can have a common label between the US and Canada. And we already discussed the prescribed ranges. The other thing is, you know, we talked about the D1 and D2 and what goes on the label versus what goes on the label in the safety data sheet. Well, many of the other competent authorities and countries only label for the product that's shipped. So now OSHA, with better differentiating between what goes on the label and what goes on the safety data sheet, is making the label more aligned with its international partners. Transition. So as Kate indicated before, I'm mindful of the time, so I'll be going through this a little bit quickly. Really, the first transition is for manufacturers. That's not until January 2026, and that's for updating the labels and safety data sheets for substances. And then another year to update the labels for mixtures, excuse me, year and a half. So then OSHA has also given an extra 6 months for downstream employers, recognizing that you may start getting a lot of new safety data sheets. An extra 6 months to update your written hazard communication program, or any workplace labels or training. So we're sort of, OSHA sort of just acknowledges that you're going to be getting a lot of changes and you don't need to be doing this on an ongoing basis. You have an extra 6 months. The last transition date is for starting from when it was published, that you can use either the older one, HazCom 2012, or the newer one that's really mainly for manufacturers. If they want to start updating their labels now, they can go ahead and start updating their labels and safety data sheets now.
And just back to the downstream employers for a minute. What I want to emphasize that downstream employers, there may be, and there will be certainly for some downstream employers, new labels and new different for the same chemical, different labels and different SDSs appearing in your, equivalent of your inbox over the next 2 years, over the next year and a half, really. And so as those come in, what Maureen's saying on the deadline is you, the downstream employer, has until July, what is the date? The exact date, Maureen?
July 20th, 2026.
Yes, July. Okay, so we've got basically 2 years to make sure that either your binder, if you're still using binders of SDSs, has been updated. So you have those new SDSs in there within that time period, or if you're keeping them in some more modernized fashion, that the new SDS is in there. One question I have, Maureen, is I wonder if an employer has the new one and the old one, so they're both in there. Technically, after the compliance date, I suppose that can create some confusion. Do you think that's a de minimis? I know you're not at OSHA any longer, but I'm curious what you think as to what the citation
I would say that
would
be de minimis, but there is probably not a reason to keep the older one. You have to maintain the current one.
Yes.
I think OSHA's biggest concern would be that the worker would be confused on which safety data sheet they should be referring to. So I don't see that as a major issue. However, their concern would be what the worker would be looking for and whether they would get the right information.
Agreed. I think that's right. And listen, if you're taking the time to take this new SDS and put it in the book, in the binder, just pull the old one out. I totally agree that arguably some confusion is created if there's a different pictogram, if there's in this case different precautionary language, hazard elements, that sort of thing. So take the old one out. I would argue to OSHA, if a citation were to issue, that that might not be the appropriate path. I don't know that there's a violation as long as you have the new one, but to avoid the hassle, just take the old one out.
Correct.
And the other thing is, you can't wait, downstream employers out there, you can't wait till the end, because you have to be knowing if new ones are coming in, right? You've got to get your training. Let's say a new hazard is identified and you do training based not on the specific chemical, but on the classification of chemicals, the types of chemicals, which of course you're allowed to do for those manufacturers who have many, many chemicals. Your HazCom training program doesn't necessarily train on each individual chemical. It may train on classes of chemicals, which is fine. But if there's a new hazard, you need to make sure that your training is updated accordingly. And also, finally, your master chemical inventory, which I don't know, Maureen, we're going to talk a little bit about, citations and how often this standard is cited. But I have had a lot of experience with employers who just don't keep their SDSs updated, but they don't keep their master chemical inventory updated. And that's a problem and a violative
That would be a
condition.
problem.
So,
Yes.
so that's important to do.
Yeah, I'm going to go over real quickly some of what you just talked about on what to do for chemical
sorry.
and manufacturers and distribution, distributors. While you have a year and a half, that year and a half will go very quickly. Really, what you should be doing now is making sure you know what your chemicals are, what chemicals you may need to update classifications for, which ones have changed. Then start updating your label. There is some flexibility, as I said, for the release for shipment. We haven't changed that distributors can still rely on upstream manufacturers. One of the things that I did want to point out that manufacturers do not need to proactively send new labels and safety data sheets for downstream users that have already bought their chemicals, but on the next shipment, they must send the updated SDS either before or with, and of course have the updated label. Similar for what Kate was saying for downstream users. Now, you can start looking at your written program and seeing, is it up to date? Is there anything that I need to be watching out for? Just to have an idea of what you have. So you're not waiting until the last minute to say, oh, what's new, what's not. While OSHA has given everyone an extra 6 months, really now is the time to get your books in order, making sure that you know what you have and what you may need to do. And similar to the manufacturers, the downstream users has no obligation to say, oh, I have this chemical, I need to go get an updated safety data sheet. No, that is up to the manufacturer for when you reorder that chemical, that they will send you the updated safety data sheet and label.
I am aware of a situation, just thinking about enforcement risks. On that last point, Maureen, I am aware of a situation a few years ago, this is before this rule, of course, where an employer was aware of an updated hazard, of a new hazard, but the chemical manufacturer had not updated their SDS. And the way we worked this out is the advice we gave to our client, which turned out to be useful and avoiding a citation. We had our client document the request to the chemical manufacturer that they were aware that there may be a new hazard associated with this chemical. The way they became aware is they saw some other SDS on a very similar chemical, not from their purchaser as supplier. And so they reached out, documented that, kept that email in their file. And in fact, there was an inspection where, because of the effort that the company made to reach out to try to get the new updated SDS, which was unavailing from the chemical manufacturer, they were not cited. I believe OSHA then went to have a conversation with the chemical manufacturer. I'm not sure how all that worked out, but
that is very often how OSHA finds out about inadequate safety data sheets. But I will be touching on that, and you're great at bringing me to the next slide, Kate.
Sorry.
Real quickly on enforcement, HazCom is still one of the most frequently cited standards. This is both in 2022 and 2023. Usually this is for high level issues. It's for either usually a lack of a written hazard communication program, or an insufficient list, or insufficient or lack of actual training, and then in the maintaining of the safety data sheet. Those comprise almost 90% of all of the citations for HazCom. So it really is more of these high level deficiencies. As I said before, manufacturers can comply with both HazCom 2012 and the current standard. And then finally, what happens if you have questions about compliance, or you don't know if you can comply? First you can contact the Directorate of Enforcement. Internally we call that DEP. for an official response on compliance, that can take a very long time. So you may want to figure something else out that's reasonable in the interim as you're waiting for the official response. And part of this is what Kate was just talking about, the good faith effort to comply. And this is where you have contacted the upstream manufacturer that, you know, I didn't receive a new safety data sheet when you were expecting it, and just document this. And if you feel that there is something that you should be training your employee, and be proactive, train your employee even if you don't have the updated safety data sheet. In a rare case when there is a new standard and you cannot comply within the compliance dates, you can apply for a temporary variance. This I've never seen really successful, maybe once, where you are telling OSHA why you can't comply, what are you doing to comply, and what to be in actual compliance, and what are you doing in the interim before you can comply. I don't see where this would affect downstream users at all, because you know, these aren't new obligations for the downstream users. It's just really that you're going to be bombarded with your obligations to keep all your stuff current, such as maintaining safety data sheets, updating your workplace, your written hazard communication program, and training your employees. So that's really it. I do appreciate you sticking through all this. I do apologize for the glitches early on. I hope everyone could hear me. Unfortunately, I haven't been able to keep track of the chat while I've been giving the presentation. So if there's any questions there, we have a few minutes that we can move on to, really,
And
you know, OSHA's going to do guidance. How about that? And then we can move on to questions.
And before you even talk about guidance, let me circle back to your slide about what to do if you have questions. And I'm going to tell you what you should do first before contacting OSHA is contact us. And there's a reason for that. It is not a distrust of OSHA, but if you were in a situation where you were taking certain actions, you believe you're in compliance, honestly, first, let's talk it over and make sure we think you are in compliance. We can give you guidance that if it turns out you're wrong, we don't cite you, but OSHA does. So you don't want to lay the facts bare with OSHA until you first talk to us. But second, there is a sort of a process that you go through. We may need, as we did in 2012, we may need a letter of interpretation from OSHA and from the Directorate of Enforcement. They work with the Directorate of Standards, the folks like Maureen's colleagues who are still there, who wrote this standard, and with the solicitor's office. There's a troika over there that will review all requests for information and interpretation of the standard, and then issue, ultimately, as Maureen pointed out, it often takes an awfully long time, but issue a response to a letter of interpretation. Those letters of interpretation are gold, that we look at those every day, all day, to determine what the law really means. But we want to very carefully make sure that we don't ask for it. You know, what's the old adage? Don't ask for the answer to a question. Don't ask for an answer to a question you don't already know the answer to, or whatever that saying is. We don't want a bad letter of interpretation. We want to know what OSHA thinks, and we want to adjust our programs as necessary. But we don't want a letter telling us on their website, you can't do this when you are doing that. So that I know we're over time already, but that's an important point, I think. So Maureen, the guidance that might come out or will come out at some point.
Really, it's going to be an update of the guidance that's already there. As Kate pointed out, this isn't a major change, particularly for downstream users, but the guidance is going to be need to be adjusted. I think one of the big things that I'm hoping will be up soon is the red line strikeout, which really shows people where the changes are and how they're being changed. And then frequently asked questions. They'll have those up on stuff that is specific to this updated rule.
And I will say though, those the red line, I hope that is out soon, because I love those documents. That it's a very crisp efficient way to understand what changed. Where you see a red line, then obviously I go and look at, you know, what the preamble says and what the language is, but it's a very nice, handy document, I think. And we are past the hour already. I'm looking backwards on the chats. Maybe we'll just grab one at least, and then we'll follow up with email responses to a lot of very good questions, I think. But the one question I see here is, oh, red line went out this week, I see. Okay,
Oh,
so the red
excellent.
line is up. I had not even seen it. All right, that's great. That's great to hear, Bruce. One question here is about retraining. Is there a requirement for downstream third-party users, so our downstream employers, to train or retrain due to changes? So let me field that and make sure, Maureen, you agree. There is not innately and organically some obligation in this standard to retrain. If you're training under the HazCom program, as you do, I'm sure, annually, then you're good, unless there has been a change that would require a retraining. I mean, sort of obvious, right? But there's not some, yes, now this new standard's out, within X number of days, you have to do a new HazCom training. That is not the case.
Yeah.
Only where there's something that impacts your current training. A new
Correct, and
hazard
that
has been identified.
exactly, a new hazard is really basically, if there's a new hazard, you have to retrain, or anything significant, different related to the hazards. This is different than 2012. 2012, we did have some training in
Yes.
that one, because that was a whole new system, and we only had people train requirements to train on the new system, and that was, you know, the label, the SDS, and the various elements.
That's right. That's right. And we've all become pretty accustomed, I think, to what used to be called the MSDS, now is the SDS. I love the fact that we now have standardized SDSs with the 16 categories, all very, very helpful. All right. Well, you know, there are a lot of questions, so I think best we let you have your time back. Maureen and I very much appreciate the opportunity to talk to you. And Maureen, special thanks to you for joining us as a special guest. We will, as I said at the outset, continue to partner with Maureen for questions related to implications associated with the new rule, the nuances that it always seems simple when you read the rule in the beginning. Then you start reading the preamble, then you start getting client questions, and you realize there's always the devil's in the details. And so
Yes.
we're doing our best to understand the nuances. Please reach out. We'll get back to you on your questions that you've sent in chat. And, you know, Maureen is now a private citizen and a consultant of her own, in her own right. And we are working with her. So through us and or directly to Maureen, please feel free to reach out. Let's make sure y'all are in compliance by the compliance dates. Thank you very much. Appreciate it. Thank you, Maureen. All right.
Oh, it was my pleasure. And thank you for bearing through the entire presentation.
Yes, and go have some water, rest, and shade, because it's getting pretty hot out there. So don't forget about heat. Okay, thanks everyone. Bye-bye.